Hey, trial attorneys, have you ever had a witness fail miserably on the witness stand and destroy his case? You're about to watch it happen. And it ain't pretty. But there's a solution. Watch and find out what it is. Buckle up.
Doctor, you took an oath as a doctor to do no harm, didn't you?
Yes.
That's the Hippocratic Oath, right?
Yes, it is.
It's your duty, as a competent physician, to not harm your patients. Isn't it?
Yes.
You'd agree that as a doctor, your top priority is patient safety, right?
Yes, it is.
So, you should always take the safest course of action when treating patients. Right?
Yes, that's right.
That includes the prescriptions you write. Correct?
Yeah?
So if a patient is harmed under your care, you'd be negligent. Wouldn't you, doctor?
Yes, that's right.
Death is harm, isn't it?
Yes, it is.
You prescribed a drug that could cause death, and you prescribed it off-label, at 3 times the recommended dose, and my client's husband died, didn't he?
Yes.
And you testified earlier that death is a form of harm. Right, doctor?
Wait, yes. I guess. Yes.
You also testified that it would be negligence on your part if a patient in your care was harmed, didn't you?
Yeah? I guess. Yes.
There's a safer drug, designed to treat the same illness my client's husband had, that doesn't have death as a possible side effect. But you didn't prescribe that one, did you?
No, but...
My client's husband died, didn't he?
Yes.
So, based on your own definition of negligence, you were negligent. Weren't you, doctor?
Yes, I guess I was.
No further questions.
That was an example of witness failure. Look how sad the doctor is. And look how happy the plaintiff attorney is. What the heck happened? The doctor agreed to something that sounded right, but was completely wrong. Did you spot it when it happened? Let's go back and watch.
Doctor, you took an oath as a doctor to do no harm, didn't you?
Yes.
That's the Hippocratic Oath, right?
Yes, it is.
It's your duty, as a competent physician, to not harm your patients. Isn't it?
Yes.
There it is. He agreed that it was his duty not to harm his patients, and it went downhill from there. He also agreed it was his duty to always take the safest course, and many other ludicrous standards. What should he have said? Let's give him a second chance.
It's your duty, as a competent physician, to not harm your patients. Isn't it?
No, that's not my duty as a doctor.
No further questions.
In take 2, the doctor paid attention to the question, refused to accept an unreasonable proposition, which shut down the rest of the plaintiff attorney's attack. Think about it for a second. If the doctor accepts the standard, that it's his duty not to harm his patients, he would never perform surgery, which literally involves cutting into a patient. Sometimes the treatment requires harm. I'm sure you can think of many other examples. What's the lesson? Witnesses not only need their lawyers to prepare them to testify, they also need a jury consultant to train them how to testify. Otherwise they will be apt to make the same mistakes our doctor made, which lost him the case. Don't let that happen to your next witness. I hope you enjoyed this video. Check out the other videos on this channel. I think you'll really enjoy them. And please subscribe.